An increasing number of new and established firms are considering offering cryptoasset services. As such, many of these firms are now required to be registered with the Financial Conduct Authority, or the FCA, under the Money Laundering Regulations, or MLRs. So what does this application process entail? On what grounds may an application for registration be refused? And if the FCA indicates that it is minded to refuse an application, is there anything which can realistically be done by the applicant firm to contest this? I hope by way of this webinar to provide an overview of the new registration regime and some practical guidance for how to navigate what is a novel and complex area. How to apply? Well, the application process is supposed to be fairly straightforward. An application is made online via the FCA's Connect system. As I've said, the application requires the provision of fairly extensive information relating to the business of the nature set out in my earlier slide. It also requires information on the applicant firm itself, its beneficial owners, and key individuals, which will allow the FCA to assess their fitness and propriety. The applicant must provide full and honest disclosure. The provision of false or misleading information may constitute a criminal offence, as well as being potentially fatal to the application itself. Finally, the applicant must pay what is a non-refundable fee, the level of which is dependent upon the level of UK cryptoasset revenue generated by the firm. So let's move on to the decision itself. Once the deadline for those representations has passed, the FCA's decision maker will consider the warning notice with its supporting material and any representations made by the applicant upon the warning notice, and on that basis decide the application. They will either decide that the applicant should be registered, or if not, they will give notice by way of a formal decision notice that the decision has been taken not to register the firm, and set out the reasons for this decision and the applicant's right to appeal against it. Appeal against the decision is by way of reference to the upper tribunal. This is an independent judicial body to which the decision may be referred, which will consider the application afresh.